Okay, welcome back everybody for our final hour. I was just thanking our panel members here for being the last ones and for you out there sticking with us. I forgot to mention at the end of Dr. Money's presentation is we have uploaded her slides. Ron did it about 10 or 15 minutes ago since she had to go through them really fast at the end. Plus there was a lot of other information that wasn't on the one handout that was there. So her slide deck has been uploaded. So our last hour, we're pleased to have Michelle and Chris and Jeff here with us live. Trish Cassel is joining us remotely, and she's going to be the moderator for this panel. Instead of sending me or Marilyn texts, there's going to be a slide up here that has everybody's, these three's cell phone and Trish's email address. They want this to be a discussion, want it to be interactive. So please, as you have comments, either text them to one of the panel members or send it to Trish. And with that, I'm going to turn it over to them, and I don't know if Trish wants to kind of introduce the purpose, the topic, or if these guys here, but have at it. Thanks, you guys.
Sure, I'll start. Can everybody hear me and see me and everything is working, I hope. I hope there's actually people on listening. And you see my email up there. What I would suggest is that you email me if you're listening. And Christian Ellie has chocolate bars that he will be sending to you. So include your address when you email me, and he will. He has them there, and he will send them to you as soon as you send me your address with the chocolate bars. What I thought we could do real quick is introduce ourselves. If you don't know us, just a quick introduction, have everybody kind of give their juvenile court experience, and then we're going to get into some discussions of some discussion points. I'm Trish Cassel. I'm the Chief Prosecutor in Summit County. I've been up here in Summit County for 4 years. I do all of the juvenile court work. Prior to that, I was in the DA's office where I was in some form or another a supervisor over the juvenile division for about 6 years. I am probably the oldest and the longest experienced juvenile prosecutor, because I also was a juvenile prosecutor in 1994-95. So I've been doing this work a long time. I serve on some boards throughout the state that do juvenile court work, and it's definitely a passion of mine, as I know it's a passion of all of these guys. So I'll start on my left. So why don't you go next, Michelle, and then you can just introduce yourself.
My name is Michelle. I work at the Weber County Attorney's Office. I've worked there basically since I graduated law school. I've been doing juvenile court primarily for 5 years. Right now, that's all I do. For a while, I did kind of a mix of district court and juvenile court, but now I exclusively do juvenile court unless I get pulled over for a trial or something like that. And I love it. So.
My name's Chris Untitled. I am a prosecutor with the Utah County Attorney's Office. I've been with that office about 21 years. I was in the civil division at the beginning. I did some work in the adult district court, justice court, and I am currently in juvenile court, which has been my favorite assignment, and I've been doing that for about 15 years.
I'm Jeff Stott. I work for the Kane County Attorney's Office, and there are only 2 attorneys in that office. And so we do everything, including civil, and juvenile court is just once a month. And I've been doing that for 5 years now.
All right, awesome. So the first discussion point we have on this panel discussion is dealing with bias in the handling of juvenile court cases. I kind of go around, see how we deal with bias. The one kind of thought that I have is, how do we deal with the bias against or for parents? I think we see a lot of in juvenile court, he or she comes from a good family, or he or she comes from not so good family. If you're from a small jurisdiction like Jeff and I are, there tend to be families that you see a lot in court. Both, you see the parents who are offending, and then you see the children coming through. And how do you deal with those biases? How do you, if you know the family, whether good or bad, how do you deal with those biases? I don't care how you start.
Well, I mean, there are good families with children that have 15 to 25 adjudications each. I mean, So I think you probably have to, realize there might be a bias if that comes up, but you have to look at the record and see, okay, have I seen this family a lot? Have I made my own assessment regarding this particular family? And get collateral information to help guide you.
When I was thinking about how bias towards families affected me, it actually occurred to me that it's gotten better since some of the reforms. Before every juvenile had an attorney in Weber County, I spent a lot more time talking to individual families. And I do think it was sometimes easier to give breaks to the parents that were well-spoken and could articulate all of the things that they were going to do to, give consequences at home. But at least in Weber County, now that every juvenile has a public defender appointed, sometimes I don't even talk to the parents on a lot of cases. I'll just work exclusively with the defense attorney. And I do think that has been probably a positive in reducing bias that I might have had towards different families, because it doesn't seem to even come up. I might not even be aware of what the family situation is unless the defense attorney tells me. We aren't so small that I am, intimately familiar with the families. We do have some repeat families that we see, but I think working with the defense attorney primarily has helped.
Because family support and parental support is a factor that we're told in whether or not a youth will be successful, sometimes we'll lean on that, right? So much that we will start to engage in this bias over the top. One thing that I thought about that helps me is in my own family, we have the same parents, and I have siblings that are very much different than I am with their strengths and their weaknesses. Some were good at school, some weren't. I can say the same with my friends. And so when I think about that, it helps me realize, even though they have the same parents, each child can be very unique and very different and successful or not, depending on their personalities.
I might also suggest to Michelle, I do think it's a benefit to deal with the attorney, but I do think if you go to a pretrial hearing and the minor is talking to their attorney and the parents are there, I think, it could be an opportunity for the prosecutor to bring the parents into a conference room and kind of talk to the parents and see what their feelings are about the case. Because sometimes even you may have a bias, but sometimes you can break through that bias by meeting with the parents, talking to them, asking them what their feelings are about the case, and kind of getting a gauge from them about what's going on with the family and what they would like to see happen with their child in the court system.
And I have we need to kind of talk about this a little bit later, but there's a question this just came in, and this would be good with what you just said, Chris. When you're talking to the parents, do you handle, and you get information from them, do you handle the cases you see fit, or do you let the family dictate the direction of the prosecution?
Personally, I don't let them dictate, but I would take into consideration what their feelings are. I could suggest certain things to them, such as, potentially, I would explain to them what the limitations are regarding the law and what they want to see happen and what realistically they could see happen in a court setting. Mostly, I would take into consideration their feelings are if they think some counseling would be beneficial for their family. I could make that recommendation. I also like to ask them, who are your child's friends that you don't think are good influences, and would it be helpful for you to have a no contact order in place? And then I would amass what they would like to see happen, and then discuss that with the public defender and see if we could reach some common ground on some of what the family wants to do. So I still think that as a prosecutor, you have to, get all the information and make a decision that you think serves the interests of justice, but also take into account potentially what the family wants to do.
And I think
I'm sorry, Michelle, but I kind of following up on what you said. Do you talk to them even though, even when the juvenile is represented by counsel? Because I'm kind of with Michelle. Now that the juvenile has counsel, rarely, I shouldn't say rarely, but not very often do I even talk to the parents. In fact, sometimes the defense counsel, I mean, obviously it doesn't let me because they don't have a choice, but they just kind of keep themselves in one room, and I don't have much of an opportunity to talk to them.
I think basically the scenarios I would do that in are where the parents are the victims. And in that particular scenario, I may or may not check with the public defender. But if I see that some parents want to engage in a conversation with me and they say, are you the prosecutor? Can we talk to you? And they're not the victim. In those scenarios, I would talk to the public defender and say, hey, these parents want to talk to me about the case. Are you good with that? Do you have any objection to that? And most often they say that they're okay with that.
Do you guys see that often when a juvenile victimizes his little sister, and that the parent almost always is worried about the juvenile, not so much the victim? That happens with me all the time, and
the majority of the cases, I think, are
they're
the same.
biased, towards the older youth and not so much the victim. They almost don't even, at least with my interactions, they almost don't even care. Not that they don't care, but they don't focus their energy and efforts on how to help the daughter or the victim.
It seems like
All
their
about the
focus
juvenile.
is the one.
And that's the bias that they bring. I don't know.
It could be their bias. It could also be their biggest concern because the alleged perpetrator is the one that is potentially being taken out of their home. So that's their focus. And I think it's tough to kind of say, well, they're not focused on the victim. But, I do get those feelings sometimes also. In those particular scenarios, I don't really normally talk to the parents because it's such a stressful scenario for them. And I mostly just work with the attorneys on kind of moving forward, creating a safety plan, making sure the victim is safe, making sure that the accused has an attorney, and that we move forward towards reunification of the family.
When I first started, I would sometimes ask those parents like what they wanted to see. And I just came to realize that was a really bad idea because you're putting them in an impossible situation. And it actually came up in the last presentation. Like officers will sometimes ask them at the scene, when they respond, like, what do you hope happens? Or do you want to see charges? And it's an impossible situation for the parents. And so I never ask them what they want to see. I usually just kind of act as providing information of what I'm doing, why I'm doing it, what my goals are here, and ask them if they have questions for me, as opposed to trying to put them in a role of advocating for one or the other, because it's an impossible situation for them.
We kind of got away from, I guess this is I got us away from that, but are there any other biases that, since that's the overriding topic of this conference, are there any other biases, if anyone wants to admit to any?
I've got one. No.
Some people are raising their hands out here. So.
I think he was making fun of me inside my finger up. But, and mine actually came up. Stephen Starr is in the audience, and he works in my office with me, and we got chatting about different biases. And he brought this up, but it was one that really rang true for me. And it's biased against repeat offenders. That you see the name of somebody, and in our jurisdiction, it's almost always our car burglars that like to steal things from cars, and if the keys are in there, they steal the car and then evade the police all night long. And we see a lot of these repeat offenders, and what we got talking about is sometimes we'll see a police report and we'll say, oh, it's John Doe again, and you feel like you don't even need to read the report because clearly he's guilty. He's done this thing 12 times, but it's just, when he brought it up, I was like, that's something that I definitely have to check. Like, is this case adequately investigated? Do I actually have evidence in this case? Because sometimes the officers do the same thing. They say, oh, it's this kid again. They just send it through without really any evidence. And if we're not doing our job as gatekeepers, we could have this bias against these juveniles that are repeat offenders, and they still have a constitutional right that we have to have evidence to prosecute those cases, even if we do know they probably did it.
And knowing Michelle, I just want to say she does read the reports. So Stephen, don't take that back with you. Okay. Steven, here's a candy bar. Oh, bad throw. Sorry. All right, I got another. Let's try that again. Nice catch.
All the people that are emailing me. I was gonna admit to a bias that I live in Summit, or not live. Well, I spend time in Summit County, but I prosecute in Summit County, right? Prosecute in Park City, and I have a lot of what I call Park City families, and a lot of entitled parents, a lot of entitled kids, and I realize who. As I was just had a case a few weeks ago that the parents and the friends and family surrounding the kid were just so inappropriate. And they wrote inappropriate letters. They did a lot of victim blaming. It was just this. I don't think I'd ever read letters that victim blamed quite like this before, and I've been doing this a long time. As one of my friends says, Trish hates rich people. That's not true, but but I appreciate the text coming in. And Judge Knight, who I respect immensely, who is the judge up here in Summit County, as I was complaining about some of these entitled families, said, Ms. Cassel, I had to separate. I read these letters too, and I finally had to separate the kid from the people around him. And she said it, in court in front of everybody. And I thought, yeah, you're right. And the kid was doing great. The kid had done everything that he was supposed to do, or has done everything he's supposed to do. And so it's the kind of, that ability to separate the kid and what the kid's doing, and if the kid's doing well. And I think it can run both ways, right? You have to separate the kid from if he's doing poorly, from the good parents, and you have to, separate. And I thought that was really good. Some of the best advice I'd gotten from a long time.
Trish, I thought I would mention, as it relates to that, something that I got from Bob, the UPC, and I think they did this in conjunction with SWAP, but it is the Utah Prosecutors' best practices. And I wrote something down about bias, which was a prosecutor should not manifest or exercise by words or conduct bias or prejudice based upon race, sex, religion, national origin, disability, age, sexual orientation, gender identity, or socioeconomic status. So I just wanted to let you know it's there. So,
and it seems like the place where that most often might come up is in casual conversations with police officers and whatnot. I feel like it's not like in court you aren't going to say something like that, although you may charge according to bias. But as far as like vocalizing that, I feel like we need to be really careful with our police officers who do an excellent job, but in helping, eradicate some of that bias, especially the ones you read.
I also got thinking about bias, gender-related bias in sex offense cases, because the vast majority of the sex offenses that we see are perpetrated by males. And so I feel like there sometimes is, when you see a female offender come in, this like, well, do they really do it? What's going on here? And that's something that I have to check. We also have had a kind of a up and down how we've treated sexting cases, where if two similar age juveniles are sending naked pictures back and forth. When I first started doing juvenile court, the practice was to charge just the male and not charge the female. And I came in and I was like, that doesn't make any sense to me, but it was two male prosecutors, and I think that they just kind of assumed that the women, that the young girls were victims in some way. But we had to look at each case and say, like, are they being victimized, or are they a complicit sender of these naked pictures, and how are we going to treat each of these cases individually? But I do think that due to the fact that most sex offenses, at least in juvenile court, are perpetrated by males, that there is a possibility for gender bias in how we prosecute.
I agree with that. If you have a female offender, and it's beyond the sexting,
Yeah.
I think it's a natural reaction of a lot of prosecutors that this is not that bad. or it shouldn't be as bad, or it's not as bad as if the perpetrator were a male. So I think you need a check on yourself at that point, and you know, kind of stop your thinking, reassess, and you know, check that bias that you might have.
Awesome. Anything else on that? We have lots of good talking points. We talked a little bit amongst ourselves, just in text and emailing, about how cases are being handled differently around the state, or are they being handled differently around the state? So are different kids in different areas being treated, of the state being treated differently? And I'm wondering, I don't know if you want me to read we had a fact situation, or if you want to just start with, I mean, what I kind of think they probably are, you know, in some ways. I think partly based on maybe just our philosophy, right? I mean, my philosophy might be different than yours, or it might be different from another attorney's philosophy. Even like if you have multiple attorneys within the same office that prosecute in juvenile court, you may have different philosophies even among yourselves. I'm not looking at you, Chris, or anything, but no, you might, you know. So
I think
how do we handle that?
Well, I agree with you. I was laughing because when I sent some talking points around to the other prosecutors who do juvenile court in our office, at least one of them said there's not even uniformity among the three of us. Mm-hmm. And so how we handle that, and what was suggested, and I agree with that, is that, well, I think we also need to talk about, do you want uniformity? Is that a good thing, or are we exercising our judgment and doing what we think serves the interest of justice in each of our cases? But it was recommended that even though we have differences, that we should be communicating with each other and screening our cases and discussing them and getting other people's opinions, like, how would you handle that? What do you think about this? Talking to your colleagues, gaining feedback. And it was also discussed, and we don't just screen that with juvenile court prosecutors. You know, we will bring this to prosecutors that are around, team meetings, office-wide meetings, or just stopping by another prosecutor's office who's around, and kind of running facts by the case by them and saying, what's your opinion? What do you think should happen? How do you view this? And then I think once you start communicating more and screening more and discussing the cases with each other, you kind of get an idea about that there is some common ground that everybody can agree upon. Okay, maybe that's getting an assessment, maybe that's asking for a no contact order, maybe that's talking about what should be in a safety plan. But we may handle it differently, but I think there are some common things that you agree upon when you're communicating and discussing the cases with your colleagues.
And I would agree with that, and that's something we definitely try to do in Weber County as well, is we regularly talk about our cases amongst Steve and I, who just do juvenile court, but we also screen them as a whole office. And I think that those differences exist even in district court, that different prosecutors and different offices have different philosophies. But I do think in juvenile court, the jurisdiction, the weird jurisdiction issue that a juvenile might commit a crime in Weber County, but sentencing and disposition will happen in a different county, does bring up unique issues. And I think that how we all handle out-of-county cases, I think, is different as well. And I was curious just how we all wanted to approach it. And I can just say that our standing policy since I started in juvenile court has been that we don't negotiate out-of-county cases at all unless basically we're contacted by the other agency and they ask us to. And so I rarely contact another agency to ask them if they want me to. My policy is just, if you want to plead guilty, or I'm talking district court trial language here, but if you want to admit, you can admit, and if you want to get a plea, you need to take it to the county where it occurred. But I'm not sure if that's how it happens across the state.
I don't see a lot of those, but every time I have, I've just called up the prosecutor. Mm-hmm. and I just ask them, do you want me to handle? But I give them kind of the say, just like you are, but I might still handle it in my
In your
court,
court, yeah.
just with whatever they are on board with. I won't make the decision just by myself.
Yeah, I do the same thing. Because I have a good relationship with Scott Sweat in Wasatch County, he's the one that does the juvenile work. He and I will communicate, and we have so many kids that because we're so close that commit cases across the county. So I'll just either shoot him an email or call him and say, I have this, this kid is yours, or mine, or whoever's it is at the time. Do you care how we do it? And the same with Salt Lake, because I know a lot of the people in Salt Lake. If I know them, I will ask. I think I sent out something to this group where I had a case with one of our kids, and I got the case to screen. It happened in a different county, and I wasn't comfortable filing it. I didn't think it was had been investigated enough. I think it probably would be filed eventually, but I thought there was more investigation that needed to be done, and the person or the law enforcement agency was in the county where it happened. So I just thought I'd send it back to that county and have them make the decision on filing. And they filed a case I wouldn't have filed. But that's whatever. Okay, that is what it is. But to me it was like I'm not gonna go negotiate that case at all. I'm gonna send that back to the county that filed it, because I'm not comfortable with it, and so I'm just gonna send it back. And I'm not gonna make a phone call. I'm not gonna I'm just gonna let them deal with it. And I think that it kind of depends on what it is. If it's a case or some sort of felony case, I'll probably send it back. Or if there's a victim, I'll probably send it back. If it's a drug case or whatever, or something that we can easily handle here, then I'll call the county attorney.
In our jurisdiction, our probation officer will first ask me what charges I recommend. She'll put it in chorus, and then she'll send it. I don't know. And then they'll decide. So I don't know. That's the policy of her, from her supervisor, which is interesting.
Wait, can you say that again, Jeff?
So before she'll send it, so in this scenario, maybe I'm confusing scenarios. If it happened in our county, but he lives somewhere else, let's see, I might be confusing him now. Anyway, before she hands it over to the other jurisdiction, she'll actually ask me to approve the charges, look at them, approve them. So I'll screen them, and then it'll go over to wherever the youth is.
And I think that's similar, that if a crime occurs in Weber County, I screen it like I would any other case, regardless of where the juvenile lives. Like if they live in Weber or Davis County, it doesn't matter. I'll screen all the crimes that occurred in Weber County the same, but then what happens with them is different. But
I think it's probably worth mentioning, if you're new to juvenile court or somebody's watching this that doesn't do juvenile court, the jurisdiction in the juvenile court can be in two places. It can be where the minor resides and where the offense occurred. So that's kind of what we're talking about. I do agree with Jeff and Michelle that if an offense occurs in your jurisdiction, at least, so Utah County does a lot of work with Salt Lake County because of the proximity. And basically, Salt Lake County and will actually want us to screen the case and file the charge if the offense occurred in Utah County.
Yeah.
And then it will be heard in Salt Lake, and then they could admit in Salt Lake or deny. or if the prosecutor in Salt Lake would call one of us or our office and ask for permission to handle the whole thing, I can't recall a time where we said, no, you can't handle the whole thing. I mean, we basically say, yes, thank you for letting us know. And then we discuss with that attorney, particulars about the case. Is there a victim? Is there restitution? Do you want anything in particular? Are you okay if we use this as a negotiating piece because this minor has a bunch of other charges, and then you kind of agree on a course of action? But it doesn't sound like Michelle or Jeff would file a petition. They only screen it and send it along with potentially a screening sheet.
No, we file a
Oh, you file it.
Well, part of the issue would be too if it's a non-judicial as well.
Yes.
And how that works into it. So
In
that's
every-
kind of why.
Yeah.
But,
Yeah, but if it is not a non-judicial, we would file a petition.
Okay.
okay.
Trish, what do you do in Summit? Do you file on juveniles and screen their cases if it occurred in your county but potentially could be heard somewhere else?
Yes.
Okay.
Yes. I will actually get both sometimes. I can never quite understand why I get cases to screen and why I sometimes don't get cases to screen. So I'll get a case for, sent to me that happened someplace else. And I would screen that too and file it if I thought, there was enough evidence. I don't have a problem, screening someone else's. It's an out of county case either.
Right.
So, but I would prefer the county where it occurred to screen. I think it's a better, and it's probably a better practice. I think, unfortunately, it kind of brings up, I think we talked about, I don't think there is a real uniform practice throughout the state. I think we do different, everybody kind of does things differently. And it would be really, it would be interesting. I don't know if it's something we, want to discuss further at some point. Do we want, and I don't know that we do, but do we want more of a uniform, at least filing? If it happens in Weaver County, it's going to go to, it's going to be screened by Weaver County.
We have had some cases fall through the cracks that made me think that more uniformity could prevent that. That I don't want anything so strict that we can't use our discretion on individual cases, but I think sometimes we think things are going to happen the way we do them, and then when they don't, it can lead to things falling through the cracks. And I also worry about victim cases when there's the jurisdiction issue of where it's being handled. That if we filed it, but it's getting resolved there, and all the reviews are happening there, we sometimes don't know if restitution or things like that are being followed up unless we're getting on of our own volition and checking care, which we might not remember to do. And so I also have concerns just about victims' rights and their interests being protected in these out-of-county jurisdictional issues.
Well, it kind of goes back to in some ways to when we have a kid who we know has had multiple offenses, and they're picking. I'm thinking of one kid in particular that he's picked up many offenses in Salt Lake. He has a couple here. He's been on kind of a tear the last 6 months. And if it were left to Salt Lake to file, not that Salt Lake wouldn't file it, but they don't know the history. I know the history of this kid, and I want to be able to have the cases come to me for me to file, even though they happened in Salt Lake. This is, I think this is what I just said. This is from somebody, an email just came out. The juvenile court where the defendant is from would know better on how to deal with the offender. And I think that's right. Obviously the court here is going to do disposition, but I feel like I know better how this case ought to be, how it ought to be resolved. I don't want it going to Salt Lake and maybe to something that either.
And I do think, and I apologize, I do think it is better for the juvenile in that the disposition can be tailored to their needs. It's just the victims that I'm concerned about, that if they're out of county, are we always aware of them, and are we keeping tabs on what their rights and their restitution and their ability to be heard at those hearings as well?
I would like to ask a question of everybody. If you have a case and it's like you're mentioning, Trish, you know this person, and you have a petition filed from your county that you filed on a case that you reviewed, and all of a sudden you get another petition from another jurisdiction on separate allegations, do you contact that jurisdiction and potentially the prosecutor that filed that petition, or would you just handle that because you know this minor and it's in your court? How do you think prosecutors should approach that?
That's a good question. I think that's I think if they filed it, I would definitely contact them. Yeah, I mean, for sure. If the kid I'm thinking of that has been on the tear for the last 6 months, I have filed everything. I have filed the 2 cases that happened in Salt Lake, and I filed the one that happened in our jurisdiction. And I think there may be something that happened in Waxahachie. I don't know. He's been arrested in multiple different places, but I have filed all of those. If Salt Lake had gotten one and Salt Lake prosecutor had filed it, I would definitely contact them, for sure.
I would say that we would also, and I think that's probably a good general practice to do that. Yeah.
We would either contact them or just refer that part of the case for them to resolve there, and then it come back for us for disposition.
We actually just did that. The kid stole a car here. We were there. Weaver County ran the cop car in Boxella County. I called Boxella and said, "Hey, when you file it, can you please transfer it down?" And I asked him to file it and asked him to transfer it down to me because this kid's out of control, and I wanted everything just to be together in front of the one judge at the same time as one big package. So that's what I did with that case.
Yeah. And were you successful?
It hasn't even gone to court yet. I don't think they filed it yet. This was last
Okay.
week. This kid's still detention. Do I get another candy bar for that?
Yeah. You got plenty. Nice catch.
All right, so I think we have gotten through quite a few cases or a few talking points. Are there any any fact patterns you guys would like to run by people, or if not, that's fine. We can move on to the more talking points. But
I'm wondering, so I don't have the luxury of a big office, right, where we do have other attorneys and multiple defense attorneys as well who can share how other attorneys are treating things. So I'm curious to see how the negotiating phase is going, especially with some of the changes. I don't know if you guys have rules of thumb when you're negotiating with defense attorney, and whether we are all about the same across the state.
Yeah, I mean, we definitely have rules of thumb that might get deviated from depending on the evidence or any factors that are different in the case. But on most sex offenses, when we charge them, we'll charge at least one per victim and just maybe a couple more depending on how serious it is, or just one if it was just once. My standard rule on sex cases is just a 402 upon successful completion of no-Joe. So I usually don't offer anything else unless there's some really good reason that the defense attorney or family can provide, like mental health issues or just something that might make it more of a mitigating factor. But I've been told that is perhaps harsher than some counties, but that is what we do. And a lot of times we'll just keep it at a felony level, and if they complete everything successfully, they can have a 402, sometimes a 2-step 402. I don't know if we want to talk about a lot of different kind of cases or just start with sex cases. But.
Well, I mean, it's really hard to say regarding uniformity and what you would do in a particular scenario. I do think that juvenile court is different, because if you were in adult district court and you took a first-degree felony sodomy on a child and reduced that to a lewdness involving a minor, you might be subject to serious discipline.
Yeah.
But if you did that in juvenile court under particular facts that you had in a particular case, it might be okay, and it might be
the right
thing to do.
Yeah.
So
we do have a lot more discretion, I think.
I don't know if you guys have found this. I have found my cases, I have far fewer cases. My caseload has gone down significantly. Like I don't know numbers, but I have half or a third or of the 2/3 of the caseload, whatever, however we put it. But what I found is that my cases are a lot more complicated. Like they've become, only cases I'm dealing with seem to be like really complicated. Really, not so much factually, but just family life is really complicated, or the fact situation is really complicated, or the kid is just, like I said, on a tear, and that's what I have found. So I have almost found that there is no there's no uniformity in what I'm doing. I mean, because I'll have one kid come in with all sorts of sets of problems, and then the next one will have a whole sorts of different problems. So I don't think that I can be uniform, because I deal with them each individually, and I almost have to, because they are so different. It's been much different for me than my district court caseload, where DUIs are handled this way and drug interdiction cases are handled that way, or we have a lot more uniformity in our district court offers than I can imagine in my juvenile court cases. I can't even imagine being uniform in those cases.
And I think that's why I started with sex cases, because for us, usually this is our first offense. I don't have to worry too much about prior history, but it is hard now with so many non-judicials, because depending on how many non-judicials they've had, or if they were successful, and if they're trying to comply, or how they're doing at school, there's just so many factors that before, if I got a marijuana case, it was almost always their first time marijuana case, and I might have kind of a standard offer. Now I have to look and say, okay, how many marijuanas have gone non-judicial, and how have those gone, or what else is going on? And it varies so much in every situation.
I will say that, a year or two ago, when you make the offer, we'd also decide on how to resolve it. Mm-hmm. And now that it's just go and get assessed by the probation officer and then disposition later, that's really simplified our offers to just what they plead straight or something else. There's rarely an agreement anymore on disposition, because of that assessment comes in between.
Question. So out of the four of you, you have to repeat this because I don't think they can hear me. We've seen a lot of changes in the juvenile system in the last few years as far as legislative changes and things, and it's really changed the landscape of how we handle juvenile court. So I want to hear from your four perspectives, what has been the single hardest change for you to do your job as a prosecutor? What has made it hard for you? Like the single thing that's just made it tough to do juvenile court work as a prosecutor?
I'll restate the question while you guys think. He asked, what's been the single hardest thing to adapt for us as prosecutors with the new changes in how the juvenile justice system operates in the last couple of years?
Well, I think the biggest thing is kind of what Trish said. I mean, you used to get to court and you would have a burglary and a sex offense or a robbery, something serious, but interspersed in there, you would have a little marijuana, you would have nude swimming, you'd have trespass, and you're like, okay, well, there's an element of less serious things that you could resolve and handle. And I do miss that. And, a lot of what I think is now you're getting into the more serious cases that either factually, like Trish said, or the family situation is really tough. And you kind of then are looking at maybe, then all of a sudden you have a delinquency case that's now a child welfare situation too, and DCFS is involved. So for me, the biggest thing is like a change in mindset, like moving from, okay, well, there's going to be some levity today, to, okay, well, I know that everything I'm going to be dealing with is probably going to be potentially felony level offense, or the minor charge is high risk. So, a lot of times the stakes are higher in those particular cases. So
there's no break, basically what you're saying.
There's no break.
Yeah.
And yeah, I would agree with that. I think a more niche issue, I've been doing the juvenile drug court in Weber County since I got started, and that used to be a really successful program where we had a lot of juveniles come on, and we'd see them apply to college and join sports teams and just have really positive outcomes in their life. And at the end, they would talk about how beneficial drug court was, and it was a really positive experience for me as a prosecutor to be part of that. And currently we have 0 people on our juvenile drug court because it's so hard to get buy-in, because we used to be able to say, we'll give you a plea in abeyance and you'll keep your license if you do this program, but now they don't lose their license if they only have drug charges. Or we're like, hey, you could do a non-judicial, or you could do this, 6-8 month long, really intensive program where you come to court every 2 weeks. And they're like, I think I'll do the non-judicial. And we're like, okay, that seems like the smart thing to do, even if it's not in your long-term interest. And so some of the cases that we used to get into the program that I think were really beneficial for the families and the juveniles, there's no reason to do it anymore. And kind of part of this that I think contributes to it is that I think that we see some cases that are just lost in the quagmire of non-judicials. They just keep doing non-judicials over and over again until it's so serious that suddenly it's blowing up on our calendar. We're dealing with things that it feels like if we could have done something earlier. And I think that as JJS gets more early intervention programs in place, that hopefully that gets better. But currently it seems to me sometimes it's like, if we could have done something a year ago, but they were still doing non-judicials at that point.
So the non-judicial and the effectiveness of maybe accountability there, is that
Yeah.
what you'd say? Okay.
But hopefully it gets better. JJS tells me it will.
And from go ahead, Trish.
Well, I was going to say is I think at least in my experience, I think it's getting better. I'm just talking. We don't have as much, youth services intervention up here, but the schools have kind of taken over a huge load. In terms, I think it was a really kind of rough learning curve. And there wasn't a lot of buy-in from the schools initially. And I think they've really, at least our schools and our district and our county have really stepped up, and they have some really great intervention programs. So I think that has helped a lot. I think that in the positive realm. I mean, I really always hated getting cases. One of my favorite kinds of cases were cases that were kids that just behaved badly at school, and the school finally just kind of threw their arms up and sent it to the court. And my thought was always, they're the school, they should be doing something. And so I think that this stepping up by the schools has been, I think, a really positive thing. And I think you're right. It's gonna, by the time we get the case, the kid, there's a lot of water under the bridge, I guess. Kids have done a lot of not a lot of intervention, but enough intervention by the time we get it, it's kind of a bad case. But I do think the positive is that our schools have stepped up and really done a great job in terms of with drugs and alcohol and just school-based offenses.
I'll add from a rural community. We saw from the earlier presentation how JJS is moving a lot of the resources towards youth services. But when you live in Kanab, 5 hours away from here, you don't have access to those resources like you do on the Wasatch Front. Some of the people have to travel 2 hours to get to Kanab. We don't have them right there, but they are expanding. They're actually doing a really good job of getting there, but they're not there now. And so we're in this middle ground of we can't access the purpose of the new law yet, and we can't use what we were using before. Yeah. So we're waiting for that to click in, and in the meantime, we feel like people are falling through the cracks.
You just described JR really well.
Trish, I'm sorry, I got a text with a question, and it probably goes to what Michelle was talking about. Can the judge order juveniles to go to drug court?
It is a voluntary program. So sometimes we'll have judges say, I really want you, in judicial language, to go to this program. And the juvenile might go for a few weeks, and then when they decide it's hard, they say, I want out, and then they leave, and there are no consequences because under the assessments, there's nothing the judges can order. So at least from what we found in our jurisdiction, sometimes juveniles will come on and then just quit a few weeks later when they decide it's too hard. And once word gets out that if you quit the drug court and then have nothing, not too many want to stay after that.
So your drug court is voluntary, and is it a plea in abeyance?
Yes.
But there's no real incentive, right,
No.
to do drug court, because most of the drug cases are handled non-judicially anyway. So there really is no incentive to do it. I mean, I'm surprised you said you have 0 participants, so.
We
I guess
had a
you don't really-
couple. The pandemic's made it worse. About a month ago, we still had 2, and then they both quit. And so now we're at 0. And I'm hoping we can keep the program alive, but it might not. We'll see. It was very successful a couple of years back.
Regarding the delinquency drug court in the 4th District, it is a plea in abeyance scenario or a post-adjudication scenario, but much like yours, Michelle, it is voluntary. So if the minor and the family don't agree to do it and aren't on board, then the court will not accept them into the program.
And they're not just drug cases, right? I mean, you would take any case that is sort of drug.
My most serious, we once had a juvenile shoot his best friend in the leg when they were all high on marijuana and Xanax, and we brought that one to the drug court. It was like they never would have got into the district court, but they came into ours, and he was actually very successful. So we take all sorts of cases, but again, the incentive's just not there anymore.
So I just have we're getting close. Steve Garson wants to end before 5. So is there? And I want to be invited back, and I know Steve makes those decisions. Is there anything else? Any other texts or anything you're getting? I've gotten a few questions that I'm not really sure. I think they've been answered. One was whether or not dropping a conviction steps would subject people to discipline from whom. I'm not sure. I don't know what that was from, or if that. Did somebody say they would get disciplined? They drop it 2 steps. I don't know that. Any other questions anyone's getting? Anyone want any other? Because we kind of touched on all the discussion points about our involvement and parents' involvement. I don't know if there's any other points that people want to make.
I just thought maybe regarding the drug court, this was also via text, an attorney from our office. That attitude on drug court needs to be changed. Okay, noted.
All right.
Yeah, I think that the one thing that we can say for those people, for all of you and for me and for everybody who's dealing with or who's prosecuting juvenile court, it can be a very rewarding experience, but I also think right now it can be a very frustrating experience as well, because we're trying to figure out what we can do for these kids, and hopefully that's where we're at, is trying to make these kids' lives better, as well as protect the communities. So I don't know. I think if there's nothing else, I think we might be done. It's 4:53. We ended early.
Sweet. Well, thank you, everybody. Appreciate those who stuck with us to the bitter end on 5 o'clock on a Friday afternoon. This may be a first for UPC. All right, 4:54 on a Friday afternoon. Anyway, we hope you had a great conference. Don't forget to fill out your evaluations, and we will see you next time. Have a good weekend.